So, thank you very much. I mean, it's not rhetoric, but it's real gratitude to Andras, to Barnard, to Kinga for these great 2 days. The venue is fantastic, and especially the thoughts and the circulation of ideas. As Joanna said, platform societies are great laboratories for interdisciplinary works, different backgrounds, and this is really a laboratory. I mean, I was really impressed, and congratulations for this. I will try to give my short added value. I know that I'm just the only one, the obstacle from us and Larry Lessig, so I will try to be as smooth as possible as obstacle. And basically, as already Kinga said, the idea is, from a constitutional point of view, to speculate on, first of all, on the new challenge of constitutional law. Because I will say things that have already been mentioned many times, maybe from a different angle, maybe I just will repeat what has been said and apologize for this. Why I say it's a new challenge for constitutional law? Because constitutional law, by design, is in a way engaged to limits power, And for many, many centuries, it was just a question of vertical relationship, authorities versus liberty. And this is something that already Joanna said when we were speaking about post-Westphalia world. This was exactly the idea of authority versus liberty in a vertical dimension, which is the new challenge that as I would say, is not totally new, but is interesting for many aspects, is that there is an horizontal dimension. The authority versus liberty is changing geometry, but constitutional law should not basically betray its own first mission, to limit power. This means basically that it's possible to change skins for constitutional law, but should always look at the origins. That means limiting powers in a vertical, horizontal dimension. Why I'm speaking about powers? It's obvious, because we are looking at the emergence of new powers. They are not totally new, but there is clear a shift from economic actors to private powers. And I will try to speculate when this happened and why. But we should also know that private entities are not the first time that emerged in a relevant environment. We know, for example, sport federations that regulate markets de facto. And they are critical companies for a certain economy, which is the new thing, the new challenge. It's simply that previous monopolists, as Miquel Maduro said, the former Advocate General, were not involved in the regulation of speech, nor in the dissemination of knowledge. Basically, the business model was not to form or to create a community of ideas. This is, for the first time, the business model of the new private powers. And this, I think, it's important. It's important because clearly it's a new challenge for constitutional law. Now, in order to try to make, if not order, to let's try to let emerge a frame. There was yesterday at least 2 times from Professor Balkin and from Lou Bosch the idea of a triangle. I will put a 3rd triangle today that will be much less original. We will see values, actors, and spaces from a transatlantic perspective. And I will try to speculate why this triangle could be important to understand which are the new challenge for constitutional law, and for what Kinga defined in a very correct way, digital constitutionalism, that we should go beyond the label, no? As usually happens, and not just be stuck in these labels. So, what about values? It's been said already that values are diverging from the 2 sides of Atlantic. I will not repeat what has been said, what you all know. Freedom of speech as Her Majesty versus dignity, first of all. Secondly, the idea of hate speech that becomes relevant only when it's been transformed in an action, Brandenburg versus Ohio. Whereas in Europe, we have something related to the idea itself that might be problematic for freedom of speech. Why? Because it's going, in any case, to harm dignity, even if there is not the transformation between idea to action. Then we know also that there is a different judicial frame in relation of the two judges, or let's say the two transatlantic courts. We know that American judges have a frame, and when I speak about frame, I refer to the idea of George Lakoff, the frame that in a way is building narrative, which is the frame of the American judge. I'm simplifying. It's basically to amplify the freedom when there is the shift from the words of atoms to the words of bits. No? Reno, Buckingham, it's exactly the idea that First Amendment is even more protecting in the new digital environment. If you move to Europe, you have something different. You see that, first of all, freedom of speech knows something that is absurd from a United States constitutional scholar, codifications of limits. For example, Article 10, paragraph 2, codifications of limits. Secondly, yes, something that is even more strange for a United States perspective, abuse of rights. Article 54 of the Convention of Human Rights, Article 54 of the Charter of Fundamental Rights, Article 17 of the Convention of Human Rights. What does it mean, abuse of rights? It's very important for example, the strategy against disinformation. I will end with this metaphors, free marketplace of ideas, and the abuse of metaphors. The abuse of rights means that the rights can be exercised, but it cannot be exploited so much in order to create harm. This is something that is very important, for example, for denying of genocide, that the European Convention of Human Rights is protecting exactly through the clause of abuse of rights. And then there is a different frame when the landscape shifts from the words of atoms to the words of bits. We have seen that in the United States there is an amplification of the freedoms. In Europe there is an amplification of risks related to the other rights conflicting with freedom of speech. Two examples, Delphi and Kapp versus Finland. You will see that in those two judgments, the European Court of Human Rights is basically saying that the new digital environment is creating more risk than the classical old medias. Why? Because there is basically the lack of the regulation, or at least the lack of domestic regulation. It's exactly the opposite of what the Supreme Court said in Reno in '97. The limitations and the regulation of the internet should be, in a way, less intrusive than, in that case, the example was broadcasting and printing, because internet, basically, it's less intrusive for minors. This is, I wonder if the Supreme Court would decide this today, if it would say the same. As has been said before by Mark, the internet of '90s is a very far relatives of the internet of today. And then we have this in relation to the values. Then we move to actors. When we move to actors, we know very well that the idea of, let's say, protecting the new gatekeepers in the '90s in the United States was due to the Section 230 that has been said, that has been already mentioned. And which was the idea? The idea was basically to promote the explosion of the internet, to basically foster the new technology. Why? Because there was something that happened before, in 1991. For example, an American court in CompuServe found that internet service providers were comparable to bookstores, to editors. So it was a reaction to the great nightmare of internet at that time, that basically there would have been a self-censorship approach. It's, by the way, the nightmare also of internet of today for certain extent. And then if we move from United States to Europe, as far as the actors are concerned, what do we see? Do we see a kind of borrowing, as Andras said already in this brilliant introduction, a kind of borrowing. It's not the same, but the notice and takedown has more or less the same cultural roots of the Section 230. It was the idea to have a minimum regulations because it was basically important to protect the freedom to conduct business and to promote the e-commerce. It's not a coincidence that the directive is called e-commerce directive. Then what happened? And this will be the second part of my presentation. It happened something that Larry Lessig described very well in a visionary book that has been already mentioned many times. It was more than 20 years ago, in 1999, Code. The idea was basically the shift from policy making to informatics, and then there is another shift that happened in the last decade from, let's say, human-centered activity to algorithms, to machine. This is something that is not totally new, but it's also clearly amplified by the new datification that was mentioned before. Which was the reaction to this new environment, to the basically shift from being just economic actors of being private powers? We have two different reactions in the United States and in Europe. In the United States, it was clear that the actors, or at least the protection of actors should not, it was impossible to change. There were some attempts to call in question the implication of a radical state action doctrine. You know very well what I mean by state action doctrine. There was the consideration to put in question the radical approach. And the idea was that a radical approach to state action doctrine could lead in digital age to the transformation of cyberspace in a totally private constitution-free zone. But as we know very well, the Supreme Court, first of all, and then the doctrine, even the more, let's say, open doctrine, Team Wu, for example, denied the possibility to go beyond state action doctrine, as Andras was saying. Just to quote what said Team Wu, that I mean, it's clearly the one that was more closed to change idea. He said that Facebook or Google may be to our speech environment, it seems much harder to say that they're acting like the government. The risk is basically to extend too much this idea and then to basically betray the roots of state action doctrine. If this is untouchable, which is the reaction of the Supreme Court? To move from actors to space, to metaphors. And metaphors should be taken seriously. As been already said in the introduction, Buckingham, the social network are the most important place for the exchange of views. Digital sphere, the new digital sphere. What does it mean in normative terms? This was already said by Andras again, by Jack yesterday. What does it mean? And this was it's not just a rhetorical question. It's a discussion within the Supreme Court between Kennedy and Alito. Because Alito is asking, shall we take seriously what you're saying about these new metaphors? If we take seriously, this means basically that public forum and viewpoint discrimination should apply also to private actors. And this was, in a way, the point that was very problematic. It was clarified by Prager versus Google and YouTube in 2020. It was very important, this, I think, consideration. Although Buckingham spoke of cyberspace as the most important place for the exchange of view in modern society, Buckingham did not and had not occasion to address whether private social media corporations like YouTube are state actors that must regulate the content of their website according to the structures of the First Amendment. This was very important because there was a confusion in relation to how much seriously should be taken that reference to the new digital public sphere, to the new free marketplace of ideas, Reno, 1997. If this is important as far as the space are concerned, there is also an important implication that sometimes the space hosted by a private person, but as a state actor, might be considered a public forum. This is Knight versus Trump. Again, Andras already recalled yesterday. I think it's important because according to some scholars, even Knight versus Trump was taken as tools to go beyond state action doctrine. But it's exactly the same decision that's saying we do not consider or decide whether an elected official violates the Constitution by excluding person from a wholly private social media account. We do not consider or decide whether private social media companies are bound by the First Amendment. This is very important, I think, because in a way it's a clarification that even if there is the reference to the metaphors, is still there the idea of state action doctrine, which has been the reaction in Europe in relation to the same problem, the shift from economic actors to private powers. It was a different reaction. It's been already recalled by Mark very well. There was, first of all, a kind of legislative fragmentation. All the legislation that has been recalled by Mark, in a way, beside the other goals that he mentioned, the goal to go beyond sometimes the paradigm of e-commerce directive. But for certain specific categories, in certain specific situations, copyright, audiovisual media service, prevention of terrorism. The idea is that there was a jeopardization that is exactly the nightmare for single digital market. Second fragmentation, the judicial one. As Federico Mancini, that was one of the judges in the golden age of the Court of Justice, said, when there is a legislative inertia, is there the judicial activism is more active. And especially in the digital context, you know very well that in the limbo, for example, for the adoption of GDPR, the Court of Justice was very active, sometimes manipulating the text, not only interpreting the text. And this was also related to the new actors, because as you know very well, there were different kind of definition, active provider, passive provider, but how active and how passive to be excluded by the e-commerce directive. This was something that clearly led to a further fragmentation. And then there was another problem related to the judicial reaction that, again, Andras recalled yesterday. The idea that, for example, in Google Spain, the Court of Justice is delegating to a private powers the role of the referees between conflicting rights. I'm not sure that they wanted, I'm speaking about Google, this new, let's say, upgrading, but for sure it was a decision, as Jack Balkin said, a new private bureaucracy that was exactly the maybe the not exactly aware consequence of that decision. Even at the national level, and I have not the time here to describe, there is a huge confusion. In Italy, for example, the same situation. Facebook removed some declaration of the extreme right parties, has been decided by the same tribunal within 2 months in a totally different manner. The first solution was Facebook was wrong in removing. Why? Because it has a special position, special responsibility. It comes into my mind the Michelin decision in terms of antitrust. When there is a dominant position, there is a special responsibility. The special responsibility here was to foster the pluralism of ideas in the digital agora. So basically, Facebook is not a private company, or at least is a private company with an injection of public role. The different solution was taken 2 months later. according to the same tribunal, Facebook did exactly the right thing, because since he had the actual knowledge of the illicit contact, and you know very well that I'm referring to the directive e-commerce, he was obliged to remove. Now, this leads clearly to a fragmentation and to the harm of legal certainty. That I think it's a real European problem at the moment, which is the possible evolution. The shift from a value-based constitutionalism to a procedural one. Now I'm referring exactly to what has been described very well before in terms of the ingredients of DSA. You can say, quoting Peter Parker, that with great power there must also come great responsibility. This is not an issue of great responsibilities, but great accountability. So my sense is that the new procedural dimension of digital constitutionalism in Europe, it's basically shifting from a value-based approach to a procedural approach. All the obligation that you know very well and has been before mentioned on the shoulders of the providers. The risk assessment, the obligation to give access and to basically enforce transparency. All those obligations have, I think, a fil rouge. The fil rouge, it's again the idea that due data process is the new keywords that basically is making the two sides of Atlantic maybe less far, because if we continue to focus on the value-based approach, the old existential dilemma, liberty versus freedom, the distance will be there. And on the contrary, the due data process is very well known by the United States constitutionalists, much more than the dignity approach. So I think this could be a solution for making the two sides a little bit less distant. And even the risk assessment that has been mentioned before could be important. But when you speak about risk assessment, then you speak about oversight. Because it's exactly how oversight is taken, which is let's say, it's very important that oversight should be taken seriously. And this, here comes the example of the oversight Facebook board. I think it's very important because it's a kind, again, of a laboratory, and there is an interesting migration of constitutional ideas. If you look at the decision related to the debt platforms in relation to the Trump account, you will find something interesting. You will see that the key principle is proportionality. So basically, it's a decision that should be based on the United States standard, but is borrowing some ideas from the European humus. And this is interesting because it's very, let's say, promising in terms of migration of constitutional ideas. But one thing is the hybridization, the migration. Another thing is the traplands. The basically borrowing of some ideas and forcing in a different context. And the example is the free marketplace of ideas. As you know very well, is the most, let's say, used and abused metaphors in the digital, I would say, constitutional law. It's been used for the first time by Justice Holmes in 1919. Then it's been used again by the Supreme Court in 1997. Internet is the new free marketplace of ideas. And finally, it's been taken when I was at the European Commission trying to suggest a new strategy against disinformation. It was taken by the European Commission saying, look, here the point is simply to believe in the self-healing ability of the market. So basically, self-regulation, and not, as was, let's say, in a way mentioning Mark, a hard regulation or core regulation, which was the mistake here. The mistake here was basically to not have been handled carefully the metaphors. As Lakoff explained us in Metaphor We Live By, metaphors should be taken seriously. They are very delicate in the sense that they basically implies a kind of transfer from the source domain to the target domain. So we should, in a way, differentiate the two parts of the metaphors. The first part is the source domain, where it's taken from the metaphors, and where it lands the metaphors. If we look at the free marketplace of ideas, we know that the first part, the domain part, is taken by the economic market, no? And the target is the communication and, let's say, constitutional market of ideas. Okay, when there's been framed these metaphors in 1999, the economic market was absolutely free. It was a laissez-faire period in which it was obvious that the liberal approach was the prevailing one. When the metaphor was taken by the Supreme Court in 1997, saying that the internet is the new free marketplace of ideas, again, in that period, the market, the internet market was free. It was free because it was, as we said, the origins. It was absolutely far from monopols and from oligopols. There were not issues of competition law. In 2018, when these metaphors it's supposed to cross the ocean and to land the European Commission, we can really say that there is the same situations in terms of the economic market and the internet market? Absolutely not. We know very well that there have been already many issues related to competition law. So basically, to force the metaphors in a totally different context has some implications, not only in terms of language, but also in terms of policy-making options. And this is something that is always neglected, that metaphors have implications on policy-making options. Which was the option? Self-regulation, that, as you know, led to a code of conduct that I was with other colleagues in the sounding board at that time, was defined the so-called code of conduct because they were missing the key performance criteria. It was really far from being a code of conduct. Now there are some improvements. But what just I want to say is that it will be my final warning. Metaphors should be taken seriously in language, in constitutional law, and in digital law. Otherwise, the risk is to be lost in metaphors and then to regret about a certain policy making option. Thank you very much.